This is very important. Nowadays, most of the judicial officers, they never practiced as lawyers. They are straight away being recruited after passing a test, and they are nonplussed what to do. So whenever any petition is filed, they promptly give a date for counter, pray time, again counter, again pray time for counter. It goes on like this. That's the orders. So they should not waste the time of the court in every small interlocutory application by giving opportunity to file counters and then hold inquiries. It's like this. Let me give one illustration. A pilot of an aeroplane, once he enters the cockpit, you might have noticed there are so many controls and switches. Many switches are on the roof of the plane because the space in front of the pilot and below the pilot, they are insufficient, so they are accommodated on the roof. Then so many dials in front, and then some big controls like landing control of the landing gear, then the rudder control, what you call steering for cars. So these things are there. The pilot will not give same importance to each and every control. Certain things require greater attention, like correctly operating the landing gear or correctly maintaining the position of the rudder or whatever it is. I'm not a pilot, but there are small switches like control of lights or microphone or whatever it is. He simply touches them. That's all. That is enough to operate it properly. Similarly, here, when the judge is conducting the proceedings, small interlocutory applications like delay condonation petitions in filing documents, then petitions to set aside ex parte orders, ex parte decrees. These things are recall of witnesses. These things, the judge can boldly say, what, Mr. Opposite Advocate, why do you waste the time of the court in filing counter and inquiry and all that? Come on, I am going to summarily allow this on heavy costs, don't worry, so that he won't repeat the same mistake again. So saying, he can get the most advocates' consent. Even if the advocate doesn't consent, doesn't matter. The judge can go ahead, and if any appeal is filed, definitely the appellate courts will support the judge, because these are all small switches, just like as I said, small switches in a cockpit. So this will go a long way in curtailing delays. So without wasting time on counters and inquiries, and if the same thing is repeated, the summary restoration may be done by imposing costs of rupees 1,000 and finally rupees 2,000. See, begin with 500, then go to 1,000, then rupees 2,000. Costs are supreme panacea for all procedural ills. This is what the Honorable Madras High Court has said. I'm not able to recollect that ruling immediately. So costs are the supreme panacea for all these procedural ills. If the same thing is repeated even after restoration of the suit for the third time on cost of rupees 2,000, the judge may give just one adjournment for filing counter, if any, to the next day by opposite side, and decline to restore the suit, citing the entire history of the conduct of the party. Of course, this may not apply if really strong ground is shown, like serious ailment of the party or advocate or accident resulting in injuries, to seek restoration for the fourth time also. Now, what are the advantages of this procedure? Advantages to litigants, junior advocates, and the judges. This procedure will give clarity and confidence to the judicial officers about the course they may adopt to deal with such tricky issues with the bar. This will also compel senior advocates to recruit competent junior advocates by paying them appropriate fee, so that the junior advocates who get opportunities to learn the work can progress in the profession. At present, they are merely confining themselves to represent during the call work and spend the rest of the day idling. When there is progress in the suits, the seniors also can afford to pay a decent fee to their juniors, whether from their own pocket or from the clients. The law also allows 1/3 fee to juniors additionally. If a senior of 15 years standing takes a junior to assist him, this facility is given. At present, seniors might not afford to pay decent fee to juniors, as courts are not showing progress in matters for fear of antagonizing the bar in restricting adjournments, or due to their lack of experience to pronounce judgments. Some new recruits in judicial officers are not pronouncing judgments even after several months of completion of arguments. The law mandates pronouncement of judgment at once. I have spoken about this in detail earlier. After hearing arguments, or at least within 1 month, and in rare cases 3 months. Then Another very interesting topic: how to deal with impolite and arrogant advocates. Though advocates are officers of the court and they are unofficial judges, according to me, and judges can be punished for contempt for insulting advocates. This is important. See, a judge can be punished if he treats an advocate with insult. This was laid down in a decision of the Honorable Lahore High Court way back in the year 1949, and this is reported in AIR 1949 Lahore 270. Though this power is there, their conduct has to be properly regulated. That means to say, the advocate's conduct has to be properly regulated by the judge, just as the Speaker of the Lok Sabha regulates the procedure therein by exercising the necessary control over fellow parliament members, including the Prime Minister, the Finance Minister, the Defense Minister, etc., who are all very powerful personalities outside the Parliament, but who should be controlled by the Speaker of the Lok Sabha. The Chairman of the Rajya Sabha also does the same thing while dealing with the Rajya Sabha members. The members can be controlled by cutting the power supply to the microphone, by calling the marshals to forcibly expel the members who resort to violence, and ultimately suspend the members for the rest of the day or for the rest of the session. Similarly, junior judicial officers and even mandal revenue officers, while conducting judicial or quasi-judicial proceedings, can control them, I mean to say the advocates, with the help of Section 345 Criminal Procedure Code. Section 345 Criminal Procedure Code, I repeat, which empowers these judicial officers to summarily try the culprit who disturbs the proceedings or attacks the presiding officer orally or physically by convicting him and imposing a fine of rupees 200. If this is not paid, even imprisonment can be imposed, not exceeding 1 month period. Advocates who behave rudely with judges also should be dealt with in the same fashion. Since the fine is only rupees 200, if an innocent advocate is wrongly convicted, he can easily pay the amount, or fellow advocates may lend that amount to him and challenge the order in appeal. Young and inexperienced judicial officers are actually scared of advocates behaving rudely and are not able to assert themselves to ensure uninterrupted conduct of the judicial proceeding. The next topic would be the demeanor of the judge towards the bar. Judges should be taught to display the right demeanor while dealing with the bar, which, as explained earlier, consists of unofficial judges. They should not assume that they are the headmasters disciplining their pupils. They should not frown at advocates or shout at them. In a school, the headmaster educates the pupils, whereas in the court of law, it is the advocates who enlighten the judge on both the legal and factual aspects of a case. Having said this, judges also should learn to be firm when enforcing the mandatory provisions of law. To illustrate, suppose an advocate unreasonably seeks adjournment. The judge should firmly curtail him by saying, with a neutral demeanor, open quote, the request for time is refused for reasons so and so, close quote. The judge should not shout at the advocate, as ill-treating an advocate is also contempt, as stated earlier. If a judge habitually displays this attitude, the aggrieved advocate should not hesitate to file a petition against the judge for contempt as per the ratio in AIR 1949 Lahore, which was already cited earlier. Similarly, during the course of trial, if any objection is taken for marking any document, the judge must crisply say, open quote, objection sustained, close quote, or objection overruled. Advocates also should, of course, be polite and respectful towards the judges. If the advocate whose objection was overruled shouts at the judge or grumbles expressing his displeasure or accuses the judge in the court hall that he is not impartial, the latter should demand an apology, failing which action should be initiated under Section 345 CRPC, as explained in detail earlier. This role is similar to that of a speaker in the legislature. How to minimize call work and expedite the judicial process. Trial of cases. Posting of cases both on the original side and the execution side, as per the civil rules of practice, is mandatory. Since mandatory provisions are like railway tracks, ignoring them amounts to derailment of the judicial train, which is harmful to the society. The following is the prescribed mandatory procedure which has been flouted all these years due to lack of commitment of both the bench and the bar to render quick justice. I am quoting Andhra Pradesh High Court rules, there may be different numbers in other High Court rules, but in all probability, the substance would be the same. So far as Andhra Pradesh High Court rules are concerned, Rule 66, it deals with preparation and publication of special list. What this rule